Lady, my lords, we were looking at Anna's Minnick. We were on page 901, just below the letter E. And here Lord Reid makes the point that the provision protects every determination which is not a nullity, but I do not think it's necessary or even reasonable, and I stress or even reasonable, to construe the word determination as including everything which purports to be a determination, but which is in fact no determination at all. So there you have a direct principle of construction that states that a statutory provision that says you shall not call a determination into question is not to be construed as covering something that purports to be a determination, but which is in fact a nullity. And the statement of Lord Reid that it's not even reasonable to construe it in that way. And in my submission, he's clearly here accepting the submission that he's set out at the top of that page. Then he deals with...
Well, he finds it quite difficult to distinguish that from Smith and Eastello. That's
yes,
the problem.
He then turns to Smith and Eastello.
But I mean, later cases have found different ways of reconciling them.
Yes.
So I wonder how much time we should spend digging around in the precise wording of these. The sort of nullity is not a very happy expression.
Well, my lord, except that the iconic force of this judgment means it must be taken to have been in the mind of the parliamentary draftsman.
Oh yes, and you'll come to tell us what you say is the ratio.
Yes. Well, indeed, my lord. So if we then go over the page at 171, here in my submission you do get the ratio between B and E. And in this famous passage, which I don't propose to read out, Lord Reid sets out the various types of error which, in his judgment, will render a decision a nullity. And this is the passage which extends the notion of a nullity beyond what was previously considered in the narrow sense to be an excess of jurisdiction, and extends it to errors of law, asking the wrong question, misconstruing the provisions giving it power to act, deciding a question that wasn't remitted to it, and so on. Then, going over the page at 904, the bottom of the page, he discusses the actual error of law that was made by the tribunal in this case, which was, as I've described it. And then he identifies at the top of 905 that if on a true construction, a claimant who's an original owner does not have to prove anything about successors in title, then the Commission made an inquiry which the order didn't empower them to make and based their decision on a matter they had no right to take into account. If one uses the word jurisdiction in its wider sense, they went beyond their jurisdiction in considering this matter. And when he says in its wider sense, he means in the sense that he has described it on the passage we've just been looking at. It was argued the whole matter of construing the order was something remitted to the Commission for their decision. I cannot accept that argument. I find nothing in the order to support it. The order requires the Commission to consider whether they're satisfied with regard to the prescribed matters. That's all they have to do. It cannot be for the Commission to determine the limits of its powers. If one party submits to a tribunal its powers are wider than in fact they are, the tribunal must deal with that submission. But if they reach a wrong conclusion as to the width of their powers, the court must be able to correct that. Not because the tribunal's made an error of law, but because as a result of making an error of law, they've dealt with and based their decision on a matter with which, on a true construction of their powers, they had no right to deal. So that is Lord Reid. Lord Morris dissented, although interestingly, he did not doubt the basic principle that this provision would not have been good to oust jurisdiction of the High Court for an error in excess of jurisdiction. He based it on the old-style distinction between excess of jurisdiction and error on the face of the record. And you see that at page 913.
I'm sorry, I was just reading Lord Reid. It's pretty clear, isn't it, on 905 D and E that that as far as he's concerned, the category of error within jurisdiction continues to exist.
Yes, but well,
It says.
well, one of the interesting things about Anismenic is, of course, that when you analyse the detail of the judgments, and particularly that of Lord Reid, doesn't completely say what the House of Lords later said it had said.
No, quite. What comes later reads rather more into Anismenic than was said.
Yes,
yeah.
I respectfully agree, my lord. But that is what is now the law of England and Wales, because Anismenic doesn't stand alone. It's the starting point of a line of jurisprudence going through O'Reilly and Macman.
We'll come to that.
But at E, he looks as if he's drawing a distinction between questions of fact and questions of law.
Yes, well, in my submission, that is the distinction that survives after Anismenic, is the distinction between questions of law and questions of fact. And in my submission also, Lord Pearce is somewhat clearer on this than Lord Reid, but I'm going to come to that in a minute.
Well, it's really the last sentence is perhaps the clearest in that paragraph below E. The question I have to consider is not whether they made a wrong decision.
Not whether they made a wrong decision.
But whether they inquired into
yes,
and decided a matter which they had no right to consider.
Yes, and of course that error lines up with the nature of the error that's alleged in our case, because in our case, the substantive complaint is that the IPT, in its preliminary decision on law, has misconstrued the scope of Section 5 of the 1994 Act, with the result that it would conclude that a thematic warrant, which didn't specify particular property that was to be hacked, particular computers that were to be hacked, it would find that that was a lawful warrant, and that the hacking of a computer pursuant to such a warrant was a lawful act. And that's a good example of where the error that we say that the tribunal has made would lead it into an inquiry which is not the correct statutory inquiry.
I find these labels very, very puzzling, I must say. Are you saying that the alleged error in your case
Yes.
on the construction of Section 5 of the 1994 Act
Yes.
was a nullity, quote unquote?
My lord, we do say that in the sense that it's described here in Anismenic, yes, it renders the decision of the IPT a nullity, because the IPT has hasn't made a substantive decision, but if it went on to make a substantive decision on the basis of that legal analysis, the substantive decision would be tainted by error of law.
Is there any error of law which does not go to jurisdiction in your submission?
No. As it's provided its material.
They are wholly synonymous categories.
Provided a material error of law, of course. Now, if we then go to we were looking at Lord Morris, and he preserves the old distinction between excess of jurisdiction and error on the face of the record. And you see that at page 182, page 913 of the external numbering. Now, then Lord Pearce is at page 925. And he says, the courts have a general jurisdiction over the administration of justice. From time to time, Parliament sets up special tribunals to deal with special matters and gives them jurisdiction to decide these matters without any appeal to the courts. When this happens, the courts cannot hear appeals from such a tribunal or substitute their own views on any matters that have been specifically committed by Parliament to the tribunal. Such tribunals must, however, confine themselves within the powers specifically committed to them on a true construction of the relevant acts. It would lead to an absurd situation if a tribunal, having been given a circumscribed area of inquiry carved out from the general jurisdiction of the courts, were entitled of its own motion to extend that area by misconstruing the limits of its mandate to inquire and decide as set out in the Act of Parliament. And that, in my submission, is one of the internal contradiction points that I made at the outset, that if you have an Act of Parliament which commences by fixing a limited area of jurisdiction for a statutory tribunal, it's inconsistent with that intention to say that that tribunal has an untrammelled power to make decisions outside the limit of that jurisdiction. Because in that event, all that Parliament has done is not to set any legal limit, but merely guidance that the tribunal can depart from at its own will and pleasure without anybody having a supervisory right. And that, in our submission, is inconsistent with the manifest intention of Parliament in passing the legislation in the first place. And he then goes on to discuss an example, and he says that you can neither extend nor reduce the area committed to it, cannot add a third condition that has to be satisfied before it will give relief. And then at 926, lack of jurisdiction may arise in various ways. There may be an absence of those formalities or things that are conditions precedent to the tribunal having any jurisdiction to embark on an inquiry, and that's what you might think of as jurisdiction in the narrow sense. Or the tribunal may at the end make an order it has no jurisdiction to make. Or in the intervening stage, while engaged in a proper inquiry, the tribunal may depart from the rules of natural justice, or it may ask itself the wrong questions. And we say that that is what has happened in this case. In the intermediate stage of the inquiry, it's asked itself the wrong questions. And that's why I answered my Lord Sumption in the way that I did. Or it may take into account matters it was not directed to take into account. Thereby, it would step outside its jurisdiction. It would turn its inquiry into something not directed by Parliament and fail to make the inquiry Parliament did direct. Any of these things would cause its purported decision to be a nullity. And then it's assumed, unless special provisions provide otherwise, that the tribunal will make its inquiry and decision according to the law of the land. For that reason, the courts will intervene when it's manifest from the record here being, of course, the judgment, that the tribunal, though keeping within its mandated area of jurisdiction, comes to an erroneous decision through an error of law. In such a case, the courts have intervened to correct the error. And then,
but not where there's an ouster clause of the kind that
historically not, no, but this is all now in the process of changing. He then distinguishes intervention from appeal, and he says that it is simply an enforcement of Parliament's mandate to the tribunal. If the tribunal is intended to inquire into and finally decide questions in a certain area, the court's supervisory duty is to see it makes the authorised inquiry according to natural justice and arrives at a decision whether right or wrong. They will intervene if the tribunal asks itself the wrong questions. Then, at the bottom of 926, he discusses the historical cases. Then, going on to page 928, at the bottom of 927, this is an important passage. He sets out a passage from Lord Esher, the Master of the Rolls, in the case of the Crown and Commissions for Special Purposes of the Income Tax. And at the top of page 928, he quotes Lord Esher saying this: when an inferior court or tribunal or body, which has to exercise the power of deciding facts, is first established by Act of Parliament, the legislature has to consider what powers it will give that tribunal or body. It may in effect say that if a certain state of facts exists and is shown to such tribunal or body before it proceeds to do certain things, it shall have jurisdiction, but not otherwise. There, it's not for them conclusively to decide whether that state of facts exists. And if they exercise the jurisdiction without its existence, what they do may be questioned, and it will be held they've acted without jurisdiction. But there's another state of things which may exist. The legislature may entrust the tribunal or body with a jurisdiction which includes the jurisdiction to determine whether the preliminary state of facts exists, as well as the jurisdiction on finding that it does exist, to proceed further or do something more. Now, I'm stressing this because in my submission it has a direct bearing on the words in parenthesis. Because what is there being highlighted by Lord Esher concerns the factual basis, not error of law at all, but the factual basis for the exercise of a limited statutory jurisdiction. And Lord Esher is there distinguishing between two different situations. The first is what is commonly known as the precedent fact situation, where the question whether a certain set of facts exist is an objective question. Of course, Kawaja is an obvious decision. Another is your ladyship's decision in the Croydon case.
I wasn't alone.
You're right, my lady, but I was thinking of your ladyship's judgment.
Yeah.
And the difference between a child and a child in need. And in that case, your ladyship distinguished between the question whether somebody is a child, which is an objective question of fact, of precedent fact, and the question whether it's a child in need, which is a question of assessment, which on the facts of that statute was for the local authority to assess. And that's the distinction that's being here highlighted by Lord Esher. Submission, that is what you have in the words in parenthesis. That's going to be my submission. And my submission is that it's of particular interest to consider that parenthesis in the light of this passage, which is actually cited in Anisminic itself. It's of further significance, as we shall see, because Kawaja, which was obviously a decision of very considerable importance in relation to the establishment of precedent facts, that was decided very shortly before the 1985 Act was passed, the first act that contained that clause in parenthesis. It was the year before. And the effect
Is this passage cited in Kawaja as well? We'll see in a moment.
I think it is, my lord, but we'd need
We'll
to check.
We'll see it.
But the key point about Kawaja is that the House of Lords decided in Kawaja that the question whether somebody was an illegal entrant was a question of precedent fact that had to be objectively established. And therefore, on a judicial review in which an individual was complaining that they had been unlawfully detained because they weren't an illegal entrant, it was for the Secretary of State to prove in the judicial review proceedings on the balance of probabilities that the person was an illegal entrant. And in my submission, if you're asking the question, why did Parliament insert the words in parenthesis, the answer is to make it clear that the IPT had the power to decide the facts which gave it jurisdiction. And not just the IPT, but also its precedent tribunals.
So you read decisions as to whether they have jurisdiction means decisions as to the existence of any jurisdictional facts.
Yes. Well, my lord, no, I say the word simply means what it says. Decision as to whether it has jurisdiction, meaning a decision as to whether the circumstances in section 65 apply, because the tribunal's jurisdiction is defined in section 65. I'm going to come to the construction of section 67.8 in a minute, but I just wanted to flag this passage because I think it's very important. And then on the same page, 928, ex parte Morgan, no tribunal of inferior jurisdiction can by its own decision finally decide on the question of the existence or extent of such jurisdiction. Such question is always subject to review by the High Court. And then at F, subjection in this respect to the High Court is a necessary and inseparable incident to all tribunals of limited jurisdiction, for the existence of the limit necessitates an authority to determine and enforce it. It is a contradiction in terms to create a tribunal with a limited jurisdiction and unlimited power to determine such limit at its own will and pleasure. Such a tribunal would be autocratic, not limited. And in my submission, that principle underlies much of the case law that we've been looking at. Going over the page again, at page 930, he discusses error on the face of the record. He then comes on to ouster at E. And then at F, it's been argued your lordship should construe determination as meaning anything which is on its face a determination of the Commission, including even a purported determination which has no jurisdiction. It would seem on such an argument the court must accept and could not even inquire whether a purported determination was forged or an accurate order which did not represent that the Commission had really decided. It would mean however far the Commission ranged outside its jurisdiction or that which it was required to do, or however far it departed from natural justice, its determination could not be questioned. A more reasonable and logical construction is that by determination Parliament meant a real determination, not a purported determination. On the assumption that either is a possible construction and that determination is ambiguous, the latter meaning would accord with the long-established line of cases that adopted that construction. One must assume Parliament in 1950 had cognizance of these in adopting the words used in 4.4. So again, the primary view is that it's not even a reasonable construction of the clause, but that in any event, any ambiguity must be resolved in the light of the long line of case law. And he then refers to Campbell and Brown, a Scottish case, Bradlaugh, which we've looked at, and at G to H, had Parliament intended to make a departure in 1950 from the more reasonable construction previously given for many decades to no certiorari clauses, it must have made the matter more clear. He then deals with Smith and East Ello. And at page 932, he refers to two facts that didn't change his mind, the first of which is that this tribunal was expressly excluded from the provision in the Tribunal and Inquiries Act, which said that no certiorari clauses were no longer of any effect. And the second was the fact that the chair was a lawyer of distinction. And then he concludes, if the Commission, by misconstruing the order in council, which gave them the jurisdiction and laid down the precise limit of their duty, exceeded or departed from their mandate, their determination was without jurisdiction, and Mr. Justice Brown was right in making the order appealed from. So that is Lord Pearce. Then Lord Wilberforce starts at page 937. And at 938, he also points out the unique status of the Commission being exempted from Section 11 of the Tribunals and Inquiries Act. And he says that specialist tribunals may have power to decide questions of law. So he is not seeking, on the face of it here, to say that any question of law would result in it being a nullity. And he also says there's no reason for giving a restrictive interpretation to Section 4.4, which provides its determinations are not to be called in question in courts of law. But then he goes on to say that in every case, however great the permissible margin of mistake, the essential point remains that the tribunal has a derived authority, derived from statute, and there's always an area which is the tribunal's area. And then at F, although in theory perhaps it may be possible for Parliament to set up a tribunal which has full and autonomous powers to fix its own area of operation, that has so far not been done in this country. The question what the tribunal's proper area is one that's always been permissible to ask and to answer. It must follow that examination of its extent is not precluded by a clause conferring conclusiveness, finality, or unquestionability upon its decisions. And again, in my submission, that is wholly inconsistent with the decision of the Court of Appeal. These clauses in their nature can only relate to decisions given within the field of operation entrusted to the tribunal. He then goes on to deal with the question of nullity at 939. And he says there are dangers in the use of this word if it draws with it the difficult distinction between what's void and what's voidable. I certainly don't wish to be taken to recognise this distinction exists or analyse it if it does. It may be convenient so long as it's used to describe a decision made outside the permitted field, in other words, as a word of description rather than itself a touchstone. The courts, when they decide a decision is a nullity, are not disregarding the preclusive clause. For just as it's their duty to attribute autonomy of decision of action to the tribunal within the designated area, so as the counterpart of this autonomy, they must ensure that the limits of that area which have been laid down are observed. In each task, they're carrying out the intention of the legislature. It would be misdescription to state it in terms of a struggle between the courts and the executive. What would be the purpose of defining by statute the limit of a tribunal's powers if by means of a clause inserted in the instrument of definition, those limits could safely be passed? And so again, he is relying on the internal contradiction argument. Then he goes on, he also cites Lord Esher, the passage we've already looked at, which you can see at the bottom of 939 going over the page. And then at 941...
It's a matter for you, but the passage on 940, beginning at F, is perhaps... we can read it for ourselves, but it's perhaps of particular interest. Essentially, he's saying that it's a matter of statutory interpretation.
To what extent?
To decide to what extent did Parliament intend this body to be able to make decisions which would not be second-guessed by courts.
That's true. Yes. And then but that point that he makes is always subject to the overriding principle that the one thing Parliament cannot have intended is that there's no limit.
Yeah.
And that, of course, is the decision which I have to address. There's no issue before your lordships of the extent of the permissible area of decision in this case because of the decision to deal with this matter by way of preliminary issue. And then at 941, he says, I don't think it desirable to discuss further in detail the many decisions in the reports in the field. 2 points may perhaps be made. First, the cases in which a tribunal has been held to have passed outside its proper limits are not limited to those in which it had no power to enter on its inquiry or its jurisdiction, or has not satisfied a condition precedent. Certainly such cases exist, but they do not exhaust the principle. A tribunal may quite properly, validly enter on its task, and in the course of carrying it out, it may make a decision which is invalid, not merely erroneous. This may be described as asking the wrong question or applying the wrong test. And he says those are not wholly satisfactory because they don't distinguish between doing something not in the tribunal's area and something within the area. So you can see Lord Wilberforce as adopting a somewhat narrower approach to this than either Lord Pearce or Lord Reid. But it is not by any means clear exactly where he's drawing the line. It is clear that he's not drawing the line at old-style excess of jurisdiction, and it's clear that he is saying you cannot have an unlimited statutory jurisdiction in a statute that purports to limit jurisdiction. Then finally, Lord Pearson dissented in the result, but as regards the legal principles, this is at page 946, he said he agreed with Lord Reid, Lord Pearce, and Lord Wilberforce. So he does not appear to have perceived any tension between them. Now, after Anna's Minnick was decided, Parliament sought to amend the relevant statute, and it did so in 2 ways. First, by introducing a limited statutory right of appeal, and secondly, it would appear, by continuing to seek to provide that outside the scope of that statutory appeal, there would still be no additional jurisdiction for the High Court. And it's instructive to see the terms in which Parliament did that. That is at Authorities Bundle 2, tab 10. This is the Foreign Compensation Act 1969. Page 1092. And you can see that, first of all, the Commission has the power to determine any question as to the construction or interpretation of any provision of an order in Council. So It's an express power given to it to construe the legislation. Then at subsection 2, an appeal by way of case stated to the Court of Appeal. Then at subsection 3, in this section, determination includes a determination which under rules under section 4.2 is a provisional determination and anything which purports to be a determination. So here we see Parliament, in response to the decision in Annis Minnick, adopting the language of purported determination. And then if you go over to subsection 9, except as provided by subsection 2 above, that's the new appeal, and subsection 10 below, no determination by the Commission on any claim made to them under the Foreign Compensation Act shall be called in question in any court of law. So that now, with an additional right of appeal and expressly extended to purported determinations. And then at subsection 10, you see that there's an express right to question determinations on the ground of breach of natural justice. Now, that's one of the reasons why we say that as a bare minimum, if section 67.8 were to have the effect, were to be construed as having the effect that the Court of Appeal said it had, it would have had to have said purported determination or purported decision as to whether it has jurisdiction. And whether you say purported determination or purported decision as to whether it has jurisdiction, that doesn't make any difference. A decision that you have jurisdiction that's a nullity is just as much a nullity as a determination. And the word purported is just as necessary in both cases. So the words in parenthesis don't advance the construction position after Annis Minnick at all. Now, in fact, this provision was never tested in court, perhaps because of the existence also of a statutory appeal right. That may be the reason, but whatever the reason, it was never subject to any court decision. But it shows you what Parliament might, as a bare minimum, have been expected to do. So that's Annis Minnick itself, which is, in some ways, a less than clear decision. However, Annis Minnick is important not just for what it says, but for what it has been treated as saying by subsequent decisions both of the House of Lords and of the Supreme Court. And the definitive approach in my submission is the approach of Lord Diplock for the unanimous House of Lords in O'Reilly and Macman. And that's at Authorities Bundle 4, tab 50, page 1961.
Ms. Rose, can we
Yes.
get absolutely clear what you are saying about the words in parentheses, including decisions as to whether they have jurisdiction?
Yes.
Right.
What we say...
The tribunal makes a decision, we have jurisdiction.
Yes.
Ms. Rose, the tribunal is wrong.
Yes.
It doesn't have jurisdiction. Why is that not a decision as to purported jurisdiction?
My Lord, what we submit is that what section 67.8 is seeking to do is to capture all the different types of decision that the tribunal makes. So it talks specifically about determinations, which is the final decision. It talks about awards of compensation. It talks about orders, which are interim orders and other orders. And then it says other decisions. And then you get the words in parenthesis. What are the words in parenthesis directed to? In my submission, what they are considering is a preliminary decision by the tribunal that it has jurisdiction pursuant to section 65. Because as we have seen, section 65 sets out an elaborate superstructure for the circumstances in which the tribunal has jurisdiction. In some cases, exclusive jurisdiction, in some non-exclusive. Now, however, so that's the nature of the decision that it's talking about, a decision whether it's got jurisdiction. But it does not say a purported decision whether it has jurisdiction, any more than it says purported determination. What's the effect of it not saying purported determination? The effect of that is that if it makes a determination which is in fact a nullity because it's tainted by an error of law, that's no determination at all, and judicial review is not ousted. Precisely the same reasoning applies in relation to the words in parenthesis. A decision, whether it has jurisdiction, which is based on an error of law, is not a valid decision that it has jurisdiction. It's a purported decision that it has jurisdiction. So the absence of the word purported from the words in parenthesis has exactly the same effect as the absence of the word purported from the words in the rest of the clause.
But what that actually amounts to is that you are saying that the meaning of the words in parenthesis is including a decision as to its own jurisdiction, provided that the latter is correct.
No, my lord.
Well, correct in law, anyway.
Correct in law,
Right.
yes. And my lord, your lordship, with respect, has just slightly amended the words.
Of course I have.
Because the
That's
question
why I'm
is
trying
not-
to test the proposition.
Is not a decision as to whether it has jurisdiction, as to its jurisdiction. It's a decision whether it has jurisdiction. And one of the criticisms that we make of the Court of Appeal with respect is that as a matter of English, the words don't mean what the Court of Appeal needs them to mean in order for its construction to be good.
But if you say in a statute
Yes.
that there is you are not to question a decision that it has jurisdiction, that must mean the question of the issue of questioning it only arises on the footing that at least it may be wrong. So the Act must say not to be questioned even if wrong, because it's not achieving anything if you say not to be questioned if it's correct. That would be the
Well,
position anyway.
That argument applies just as much to the words outside the parenthesis that your lordship might put to me, if we didn't have Annus Minnick, that a provision that says you are not to question a determination of the tribunal only applies if the determination is wrong.
Well, that depends.
But we know that what that means is that if the determination is a nullity, therefore a purported determination, not a valid determination, because of a sufficiently material error of law, then that clause doesn't bite. And exactly the same analysis applies to the words in parenthesis. And if your lordship asks me the question, what then is covered by the words in parenthesis, the answer is the findings of fact that the tribunal has to make in order to decide whether it has jurisdiction. And if you ask what is the purpose of the words in parenthesis, how is this a development of Annus Minnick, the answer is that this is the second of the situations identified by Lord Esher and expressly referred to by the House of Lords in Annus Minnick. This is a situation in which Parliament is expressly bestowing on this tribunal the power to make the findings of fact, findings of precedent fact, that determine whether it has jurisdiction.
But I think the logic of your submission
Yes.
is that even if the words in parenthesis said, including a decision as to its own jurisdiction, as to the factual or legal basis of its jurisdiction, I think your submission would be exactly the same. It's the submission you made a moment ago.
Your lordship's right, because the absence of the word purported would still be a problem. Because it's exactly the same flaw.
Just for that reason, just because of the absence of purported. Because the problem about that is that
as a minimum, my lord.
a purported decision is basically shorthand for a decision
Invalid
that's wrong.
decision. Yeah. Well,
So one's going back to my hypothetical question about what if it had said,
yes.
about your reading it as saying, provided that it's right.
Yes. And what your lordship says is an objection that may be made to the analysis of the House of Lords in Annus Minnick. But Annus Minnick exists, and Parliament legislates on the footing of Annus Minnick. And if Parliament chooses to legislate without using the word of purported determination or purported decision, then that has obvious consequences.
But Anna's
for the
Minute did not
inversion.
have words equivalent to the words in parentheses.
Indeed, it didn't, my lord.
And
But
we're-
the point I'm making to your lordship is that the distinction your lordship draws between the words in parenthesis and the words outside parenthesis is a distinction without a difference. Precisely the objection that your lordship makes in relation to the words in parenthesis can be made with the same force in relation to the words outside parenthesis. It's not a material difference. That's why I stressed at the outset that our case is that there is no material difference between the wording in this case and the wording considered by the House of Lords in Anna's Minute. In both cases, the matter that cannot be questioned is only a valid decision or a valid determination, not a nullity. Now, what does that mean? In my submission, it means that this tribunal does have the power to find the facts that establish its jurisdiction. This is not a coadjutor situation where the question whether or not a warrant has been issued in challengeable circumstances. That's a question of fact. And that's not something that the tribunal would have to establish as an objective fact on the balance of probabilities if there were a challenge. It has the power to do that, and that's what the words in parenthesis bestow upon it. What it doesn't have is the power to err in law when deciding that it has jurisdiction. It doesn't have the power to decide that the county court is not a judicial authority, and that therefore it can hear a complaint about surveillance pursuant to a warrant issued by a county court. It doesn't have the power to do that.
Could I raise with you another possible reading of the words in parentheses?
Yes, my lord.
Could I just, before we go too far down this road, you had, I think, planned to have a whole section dealing with the words in parentheses, which my Lord's question diverted you backwards to.
It's true.
And I'm rather worried that this is such an important part of the argument that to anticipate it before you've got us there will actually make it more difficult for you.
Well, my lady, I'm grateful. May I, I'm aware also of the march of time. May I just complete what I need to say about the case law?
Yes.
I was about to turn to O'Reilly and Macman, which is at Authorities Bundle 4 at page 1961. And if you read O'Reilly and Macman after reading all the earlier authorities, it's like a situation where you've been groping in a dark forest and suddenly you come out and see the sunrise, because suddenly you see the birth of modern public law. And when you look at the individuals who were counsel in that case, it's perhaps not a surprise that it should be so. But amongst the things that Lord Diplock said in this case are at page 2002, where he gives his analysis of Anna's Minute. And in a way, it is this passage which is now more important than Anna's Minute itself.
Sorry, which page again?
Page 2002. Lords Fraser, Keith, Bridge and Brightman all agreed with this. So opposite D, he sets out the ouster, and he identifies the leading speech of Lord Reid, which has liberated English public law from the fetters that the courts had theretofore imposed upon themselves as far as determinations of inferior courts and statutory tribunals were concerned. You will note that he says they're inferior courts and statutory tribunals. And you will have seen in our note dealing with Re-Rakel that we make the point that Lord Diplock himself accepted that Anna's Minute applied to both courts and tribunals. By drawing esoteric distinctions between errors of law committed that went to their jurisdiction and errors of law committed by them within their jurisdiction. The breakthrough the Anna's Minute case made was the recognition by the majority of this House that if a tribunal whose jurisdiction was limited by statute or subordinate legislation mistook the law applicable to the facts that it has found them, it must have asked itself the wrong question, i.e. one into which it was not empowered to inquire and so had no jurisdiction to determine. Its purported determination, not being a determination within the meaning of the empowering legislation, was accordingly a nullity. Now, whether that is actually what was said in Anna's Minute is less important than that that is how it has been understood and explained.
This is an obiter dictum, isn't it?
It is, my lord, but it's an obiter dictum that is then repeated again and again and again. And in our written case, you have some of the occasions on which it has been cited. And it's an obiter dictum that has behind it the full force of a unanimous House of Lords. And in my submission, its significance is even greater in this context because this is a judgment from 1983. It's shortly before the first of the ouster clauses we're concerned with was drafted. And in my submission, in the light of this decision, of this significance, it simply cannot be that Parliament can be taken by the wording at 67.8 to have entirely intended to exclude judicial review for error of law. It's an impossible construction, my lords, my lady. Before I leave it, just for the court's note, he describes on the following page the expansion of certiorari from purely judicial bodies to quasi-judicial and then administrative bodies as well. We have summarised in our written case at paragraphs 44 to 48 the principles that we say are properly to be derived from Annus Minnick, and I invite the court to consider them. I don't propose to repeat them. And the more recent decisions of the Court of Appeal, the House of Lords, and this court, in my submission, are entirely consistent with what Lord Diplock there said in O'Reilly and Macman. Now, again, in our written case, we've set out a number of the cases, but the one I want to focus on is Cart. Cart both in the Divisional Court and in the Supreme Court. And you have Cart in Volume 1 of the Authorities Bundle. The Divisional Court is behind tab 4 and the Supreme Court behind tab 6. And as I said, I want to turn first to the Divisional Court. As I said earlier, in the Divisional Court there were two cases. One was Cart and the other was Yu and SIAC. And that is the one of more direct relevance because that was a claim for judicial review by an individual whose bail had been revoked by SIAC following an entirely closed process. And his argument was that it was a breach of his Article 6 rights for his bail to be revoked and for him, therefore, to be imprisoned on the basis of a case, none of which had been disclosed to him. And he was met with the argument that there was no jurisdiction for judicial review. There is a statutory appeal from SIAC, but it did not cover interim decisions, including bail decisions. So there was no statutory appeal for this decision. SIAC, under the statute, was designated as a superior court of record, and there was also an ouster in materially similar terms to that in Annus Minnick. And it was held by the Divisional Court that neither the clause making SIAC a superior court of record nor the Annus Minnick clause were sufficient to oust judicial review for error of law, even given the national security context. So it's also notable that SIAC had to be presided over by a High Court judge. And we see that if you go to page 961, paragraph 5, you see the provision for who has to preside over SIAC. So that, again, makes it much more court-like than the Investigatory Powers Tribunal. Then paragraph 6, page 962, there is description of SIAC's jurisdiction in the national security sphere. And at E to F, description of the specific provisions for closed material proceedings. Then at paragraph 8, you have the ouster. Commission should be a superior court of record. A decision of the Commission should be questioned in legal proceedings only in accordance with, and those are the specific statutory appeal provisions. Now, again, in my submission, on the face of it, this is a more strongly worded ouster than the ouster in our case, because the anismonic wording is combined with an express statutory provision making this a superior court of record. And then at paragraph 28, page 969, Lord Justice Laws for the Divisional Court comes on to consider the question of the exclusion of judicial review by statute. And the first point that he makes is that simply labelling a court a superior court of record is not sufficient to oust judicial review, whether or not in substance judicial review will lie against a superior court of record. And you can see that at 31 he cites Siva Subramaniam. That is a case which concerns judicial review of the county court, a decision by the county court refusing permission to appeal. And even in that context, Lord Phillips makes it clear that you cannot oust judicial review by implication. He then cites authorities at paragraph 32 that will be very familiar to this court. He then, at 33, says, well, what's the reason why the case law is so restrictive? And he then gives a constitutional explanation about why the courts are so reluctant to countenance the statutory exclusion of judicial review. And I invite the court to read from 34 down to 40, where he sets out his analysis. And his analysis is essentially that it's an essential part of parliamentary sovereignty, that there is an authoritative interpreter of the laws that Parliament makes, and the authoritative and independent interpreter has to be the High Court or the equivalent of the High Court. Paragraph 38, he says Parliament can't dispense with that. At 39, he posits the idea of the alter ego of the High Court, and as this court will recall, ultimately his conclusion that the upper tribunal was such an alter ego was disagreed with by the Court of Appeal, and this court upheld the Court of Appeal on that point. So that is his constitutional rationale, and we rely on those passages in support of the second issue in this case. He then goes on from paragraph 44 onwards to discuss the historic role of the Court of King's Bench and its historic powers to supervise even other courts of record. And in particular, at paragraph 51, he makes the point that the King's Bench was a common law court of unlimited jurisdiction which had developed a general power by means of the prerogative writs to supervise other courts, courts of limited jurisdiction, to ensure that the limitations were respected. Those powers devolved to the High Court on the coming into effect of the 1873 Act. They have in practice been exercised since then by the Queen's Bench Division, and in recent years more particularly by the nominated judges of the Crown Office list, now the Administrative Court. So, as Lord Justice Laws is there making clear, the common law supervisory power of the Court of King's Bench was then enshrined in statute in 1873, and of course more recently in the 1981 Senior Courts Act, which preserves the common law jurisdiction of the High Court. He then goes on to consider what is meant by superior and inferior courts at paragraph 54. He makes the point about whether or not there is a presumption that courts have jurisdiction or whether they must establish their jurisdiction. That again in my submission is relevant when you consider the words in parenthesis. There's no doubt that the Investigatory Powers Tribunal is not a court of record, and therefore it is a court that must establish its own jurisdiction. in general terms, without the words in parenthesis, it would be for the IPT, if its jurisdiction were questioned in any other court, to satisfy that court on the balance of probabilities that the facts justifying its jurisdiction existed. The words in parenthesis, as Lord Esher explained in the Inland Revenues Commissioner's case, mean that in the case of the IPT, that factual assessment is a matter for the IPT itself. They don't entitle the IPT to err in law when deciding whether they have jurisdiction. He then essentially concludes that the true contrast, this is at paragraph 68, the true contrast is between the High Court on the one hand and courts of limited jurisdiction on the other. And we respectfully submit that he is right about that there isn't any other principled distinction that can be drawn. He then concludes in relation to SIAC that SIAC is not analogous to or the alter ego of the High Court and therefore is judicially reviewable, but reaches a different conclusion in relation to the upper tribunal. And it's that latter finding, paragraphs 87 to 89, which did not survive on appeal. That then brings me to the Supreme Court's decision in Carte. By this time, it was no longer being argued by Her Majesty's government that the designation of the upper tribunal as a superior court of record was sufficient wholly to oust the power of judicial review. Instead, what was being contended for was a highly restrictive approach to judicial review that essentially resurrected the old pre-anisminic distinction between error on the face of the record and error going to jurisdiction. And that analysis was rejected by the Supreme Court for a number of reasons, amongst them being the fact that that was a distinction that was no longer valid following anisminic. And so that is a recent instance where integral to the ratio of this court is a decision that anisminic abolishes the distinction between error of law within jurisdiction and error of law going to jurisdiction. The leading judgment given by your ladyship, and just going through it, the history starts at paragraph 11, and your ladyship gives a detailed history of the development of statutory tribunals, which is relevant, of course, to the IPT, just as it is relevant to the upper tribunal, and that goes down to paragraph 21. Anisminic is described at paragraph 18, and your ladyship says that, that in holding that nevertheless it was not effective to oust the jurisdiction of the High Court to set aside a decision, it was a nullity, and that a decision made in error of law was a nullity, the House of Lords effectively removed the distinction between error of law and excess of jurisdiction. There is then a description of the upper tribunal established under the Tribunal's Courts and Enforcement Act. And then at paragraph 30, my lady describes the judgment of the Divisional Court. And your ladyship says that the argument that there was an ouster of judicial review was comprehensively demolished by Lord Justice Laws, with whom Mr. Justice Owen agreed, in a typically subtle and erudite judgment to which the following brief summary cannot do justice. And then your ladyship summarises the key points of that judgment. And then, in the light of that comprehensive demolition, Mr. Eadie has not since tried to rebuild the argument. He doesn't need to do so because he's simply saying that judicial review is limited to exceptional cases. And in my submission, the analysis of Lord Justice Laws is not only subtle and erudite, it is, with respect, correct.
I suppose it's possible that a subtle and erudite discussion might be entirely misconceived.
It is, my lady. But in this case, it was so overwhelming in its force that it led to the comprehensive retreat of Her Majesty's government. We're not perhaps necessarily known for conceding points unnecessarily. But in any event, my submission is that what Lord Justice Laws says is correct. And the area where he erred is described at paragraph 32, which was whether or not the upper tribunal was in truth standing in the shoes of the High Court. And your ladyship here quoted Lord Justice Sedley in the Court of Appeal. The upper tribunal is not an avatar of the High Court at all. Far from standing in the High Court's shoes, the shoes the upper tribunal stands in are those of the tribunals it has replaced. And then at E, on the following page, 1053, two principles needed to be reconciled. One was the relative autonomy that Parliament had invested the tribunals as a whole, and the upper tribunal in particular. The other was the constitutional role of the High Court as guardian of the standard of legality and due process. And then we see the resurrection of the distinction between legal error and jurisdictional error in the quote that's there set out. And your ladyship then at paragraph 37 comes on to consider the various options that are open, and there at 37 says that the argument that making the upper tribunal a superior court of record ousted judiciary was killed stone dead by Lord Justice Laws. And then your ladyship identifies the three possible approaches that were being advanced. One, the approach of normal judicial review, that the upper tribunal's decisions on permission to appeal should be judicial reviewable on all normal judicial review grounds. Secondly, the pre-anisminic distinction between jurisdictional error and error on the face of the record, or error within jurisdiction. And thirdly, the midpoint, which was adopting the approach taken on second appeals, that not every error of law would lead to a judicial review, but only if there was an important general point of principle. And then at paragraph 39 to 40, your ladyship rejected the first of these routes. And at paragraph 40, rejected the idea of a return to pre-anisminic jurisdictional versus non-jurisdictional error. And the first point that your ladyship makes is that we'd be reintroducing a distinction which had become relevant for the most part only where judicial review was expressly excluded, which is not here. But then your ladyship went on. Secondly, the distinction was given its quietus by the majority in anisminic, not least because the word jurisdiction has many meanings, ranging from the very wide to the very narrow. By the narrow original sense, both Lord Reid and Lord Pearson meant that the tribunal had asked itself the wrong question. But as Lord Reid explained, a tribunal does this if it does any of the things that would ordinarily render its decisions susceptible to judicial review. And as Lord Pearson observed, there's been evolution over the centuries and many technicalities. There have also been many borderline cases. Lord Wilberforce did not find the expressions asking the wrong question or applying the wrong test wholly satisfactory, though he agreed such decisions were a nullity. If the approach of the Court of Appeal in Cart is maintained, we may expect a return to some of the technicalities of the past. So that was a reason in principle for not resurrecting that distinction. And then thirdly, as Lord Wilberforce pointed out, it does, of course, lie within the power of Parliament to provide that a tribunal of limited jurisdiction should be the ultimate interpreter of the law which it has to administer. The position may be reached that even if they make what the courts might regard as decisions wrong in law, these are to stand. But there's no such provision in the 2007 Act. There's no clear and explicit recognition that the upper tribunal is to be permitted to make mistakes of law. Certain decisions are unappealable, and for the most part there are obvious practical reasons why this should be so. This does not mean the tribunal must always be permitted to make errors of law when making them. Now, our second submission is to the effect that, in fact, there is no such power. But even if I'm wrong about that, in our submission, the clause with which we're concerned here doesn't come close to satisfying this test, because nowhere does it say that this tribunal has the power to make errors of law. And indeed, by adopting the anisminic wording, it must be taken to have intended the opposite. And your ladyship then goes on to explain why it's extremely undesirable to permit errors of law to be made by specialist tribunals. It's at paragraphs 43 and 44. And here your ladyship identifies the problem of local legal islands, local law, and the risk that you could have inconsistent interpretations of the law developing in specialist tribunals from those applied in the general court. And in our submission, that risk is precisely engaged by this case. And the most obvious example of that is that this tribunal has to apply the Human Rights Act. And the court already has my point that in many cases its jurisdiction will overlap with common law torts, including trespass or assault. And there is a serious risk that it may adopt legal definitions that are inconsistent with the common law. So that's your ladyship's approach. Then Lord Phillips at paragraph 61 agrees. At paragraph 71, he said, the power of the High Court to conduct judicial review subsists alongside these statutory provisions for appeal. It's not, however, the practice of the court to use this power where a satisfactory alternative remedy has been provided by Parliament. Now that's a very important point, because it will often be the case that Parliament provides a statutory remedy. It might be a statutory appeal to the High Court or to the Court of Appeal. In that case, the jurisdiction of the High Court to entertain judicial review is not ousted, but as a matter of discretion, the High Court will not entertain a claim for judicial review if there is an effective alternative remedy. And in my submission, that is the true rationale of what is happening in the Carp case itself. There's no ouster of jurisdiction. It's simply a discretionary approach to be taken by the High Court as to the circumstances in which it will or won't entertain an application for judicial review from a decision of the upper tribunal refusing permission to appeal. And then over the page, Lord Phillips refers to Annis Minnick and says that there the House of Lords finessed. And your lordships and your ladyship will notice the word finesse there, which perhaps bears on the point that Lord Sumption was putting to me, that you can certainly make the case that the construction of the Foreign Compensation Act, which was adopted by the House of Lords in Annis Minnick, was highly contrived, for the reasons that Lord Sumption put to me specifically by reference to the words in parenthesis. Now, in that sense, it forms part of a very long and honourable line of case law in which courts have strained every muscle to avoid even no certiorari clauses having, or what on the face of the clause appears to be its obvious meaning. And that, of course, in itself supports my argument. But more fundamentally, after Annis Minnick, Parliament using the Annis Minnick phrase must be taken to know what it means. Lord Phillips then goes on to say, since that case, Parliament has not purported, as it might have done, expressly to preclude the exercise by the High Court of the power of judicial review. Now, I stress that because Lord Brown agreed with Lord Phillips's judgment without qualification. And this was after the judgment given by him in A and B, a case on which the government relies in this case, an obiter dictum by him suggesting that Section 67(8) is an unambiguous ouster. Now, our submissions you will have seen in relation to A and B are that that matter was not an issue in A and B. Indeed, it was expressly conceded by the claimant in that case that there was an unambiguous ouster, and it's clear that Lord Brown didn't think he decided anything very important because he was then prepared to sign up to this statement of Lord Phillips without qualification. At paragraph 73, Lord Phillips notes that the position of Lord Justice Laws that Parliament doesn't have the power wholly to oust judicial review is controversial, and says he hopes it will never be necessary to decide it. That is also my hope. Lords Hope and Roger agree at
Can you
paragraph...
just get paragraph 91 and 92
Yes,
interested
my
me,
lord.
because, I mean, in a way they go to your point that actually this is a sort of court. Paragraph 91, he gives the alternative view that the
Yes.
tribunal system was a self-contained system with its own system of appeals and so
Yes.
on. And then at paragraph 92,
Yes.
he moves to My Lady's position, but sort of pro tem almost. He says, let's see how the tribunal system
Yes.
works.
But in my submission, he's talking there entirely about discretionary exercises of jurisdiction.
Well, yes, I mean, I think it really goes to your point that
Yes.
this is an example of the court saying, yes, we have jurisdiction, but it doesn't mean we
Necessarily.
exercise. We
Absolutely.
lay down rules for a very restrictive exercise because of the framework Parliament has set up.
Exactly. And my lord, that approach, of course, is entirely consistent with the common law supervisory role of the High Court. Because just because the High Court has the power to supervise doesn't mean that it will always operate according to a rod of iron. It will give very considerable leeway to expert tribunals to make expert judgments. This is all trite law. But the key point is that its power always remains. Lord Hope and Lord Roger agree at paragraph 96. And Lord Brown, you can see, agrees at paragraph 97. Lord Clark at 102 also agrees, and Lord Dyson at 108, 110, and finally 133. So that is the case of Cart, which in my submission makes very clear what the current state of the law is in relation to anisminic and error of law. Now, there was a separate decision in relation to Scottish law raising the same question, and that is the case of Ebba, which is in Authorities, Volume 6, at tab 76. And this decision is in a context, page 2830. This decision occurs in a context in which there were decisions, and in particular a case called Watts, which still maintained in Scots law the distinction between an error in excess of jurisdiction and an error on the face of the record. And in this case, the Supreme Court decided that as a matter of Scots law, that was no longer a valid distinction and the anisminic approach ought to be applied. And if we go to paragraph 26,
Of course, the law that they were looking at in Ebba was actually United Kingdom law, wasn't it?
that's true, that's true. But
It happened to be a Scots case, so
Yes.
Scots principles of public law about what happens in tribunals were no doubt applicable, but the actual substance of the law was the same.
Well, the statutory provision was, but the question of the substantive grounds on which judicial review could be entertained was a question of Scots law. So, yes, and exactly, and of course, RIPA is itself a United Kingdom statute, and exactly the same points are applicable, which is why I'm showing this to the court. So, paragraphs 26 and 27, there is a discussion of some of the differences, the procedural differences in relation to judicial review in Scotland as opposed to England, because in Scotland it is a matter of right, not of discretion. There is then a description of the maintenance of the distinction between error of law within jurisdiction and error of law in excess of jurisdiction from Watt and the Lord Advocate. That starts at paragraph 29. And then at paragraphs 33 and 34, as the Lord President observed, the anisminic case has come to be interpreted and applied in the English courts in a way that does not appear to sit easily with Lord President Emsley's dictum. And I would respectfully agree that that is the right approach, that anisminic itself is somewhat less than clear, but it has subsequently come to be interpreted and applied in that way. The distinction between jurisdiction and other errors which he was endorsing has been abandoned. And then at paragraph 34, the conclusion is that the same approach should be taken in Scots law. And then at paragraph 43, there is a specific rejection of the jurisdictional error approach. And then at paragraphs 44 to 47, the same conclusion is reached in relation to Scots law as was reached in Cart in relation to English law. Before I leave the issue of Scots law, I just want to give you references to two old Scottish cases concerning ousters, which take at least as strict an approach as the approach taken by the English courts. The first is a case called Campbell. That's Authorities Bundle 9, tab 100, page 3710. And the second is the Rothesay Magistrates Court. That's at Authorities Bundle 9, tab 101, page 3718, and in particular pages 3720 to 3728. So we submit that all the points I've made in relation to the development of English law and what Parliament must be taken to have understood apply with equal force to Scots law. We have in our written case also dealt with other Commonwealth jurisdictions. I do not have time to turn those up specifically, but can I just draw to your attention our written case, paragraphs 55 to 80. Some of these cases are very striking because of the extraordinary breadth of the ouster clauses that were held not to be sufficient to oust judicial review, and because of the repeated enunciation of the two fundamental constitutional principles that I've identified. First, that it's a contradiction in terms to set the limits of a tribunal's jurisdiction and then say it can exceed them. And secondly, the provision that Parliament must be intending there to be an authoritative and independent interpreter of its decisions. And can I just, without looking them up in detail, refer you in our written case, first of all, to paragraph 56, and at paragraph, it's page 122 in Core Volume 1. And we make the point at paragraph 56 that the logic of Anna's Minnick has been applied to ouster clauses far more clearly and unambiguously drafted than section 67(8). And we set out the clause that was at issue in the New Zealand Waterside Workers' Federation. Just invite the court to see what that clause says. It's much, much broader than anything we have in this case. And the key passage in which the effectiveness of that clause as an ouster was rejected, we have set out going over to page 123. Then we set out the clauses that applied in two Australian cases, and you will note in particular at 56.3, this section extends to proceedings brought in a court or tribunal in respect of a purported decision of the Commission on an issue of the jurisdiction of the Commission. And such a decision is final, may not be appealed against, reviewed, quashed, or called into question by any court or tribunal.
There's an interesting note at the bottom of your paragraph 62 that the Kirk case in the High Court of Australia didn't like the lumping in of any error of law as being ultra vires, which leads me generally to ask you, when we read these cases, we read all our colleagues rejecting certiorari exclusion clauses,
Yes.
are they rejecting them in favour of there being a legitimate inquiry into jurisdiction in the narrow sense, or in the wider sense, with which we seem to have been landed?
The answer, my lord, is that some are doing it in the narrower sense and some are doing it in the wider sense. But none of them are doing it in the sense that the Court of Appeal did it in this case, which is in totality. That's the case I have to meet, that this clause excludes all judicial review. It's not before your lordships whether it excludes it only in relation to jurisdictional error. Now, my submission is that that outcome would not be a possible one in the light of Carte.
Well, we must keep our eye on the ball. You're complaining about the misconstruction of Section 5.
That's correct, my lord. It's a pure question of error of law, which in our submission leads the tribunal to ask itself the wrong question.
Yes.
So those are simply some striking examples of ouster clauses far broader than 67(8) that have been held ineffective to oust judicial review all over the world. And the court will have in mind, dictated particularly by Lord Newburger, as to the desirability of common law courts adopting consistent approaches. Now, there is only one occasion on which Parliament has ever even attempted to draft an ouster clause that would comprehensively address the issues raised by Annis Minnick and the subsequent case law. And that was in 2003, Clause 11 of the Asylum and Immigration Treatment of Claimants, etc. Bill. Now, that clause you will find set out at page 118 of Core Bill 1, under paragraph 51 of our written case. And I draw it to your attention because in
Sorry,
my submission,
what was the page reference?
Page 118, my lady.
Thank you.
I draw it to your attention because in my submission this shows the kind of drafting that you would expect to see as a minimum if this was a case where Parliament was seeking to oust judicial review. This is what you would have to see. And you can see it in the middle of page 118. No court shall have any supervisory or other jurisdiction, whether statutory or inherent, in relation to the tribunal. No court may entertain proceedings for questioning, whether by way of appeal or otherwise, any determination, decision or other action of the tribunal, any action of the president or deputy president. Subsections 1 and 2 prevent a court in particular from entertaining proceedings to determine whether a purported determination, decision or action was a nullity by reason of lack of jurisdiction, irregularity, error of law, breach of natural justice or any other matter. Now, in my submission, the inquiry that you are required to make by centuries of case law is whether there is a clear, specific, unambiguous ouster of judicial review. This clause is the closest to it that you will ever see. What happened? There was an outcry, which we describe in the following pages. There was a constitutional crisis, and the clause was not enacted. Now, that in my submission shows you the principle of legality as identified by Lord Hoffman in Sims operating in exactly the way that it should. Because the whole point of the principle of legality is that Parliament is required squarely to confront a provision if it is seeking to do something that is a significant interference with a basic constitutional principle, and then take the political consequences. And what happened in this case was that the political consequences were unacceptable and the clause was abandoned. And in my submission, when you look at that course of events, you have to ask, how can it be that section 67, subsection 8, which contains none of these provisions, none of these red flag provisions that would alert anybody to what was intended, but which is on its face no more than the same type of clause considered in Annis Minnick, good to oust appeal or review on fact, but not to oust review for error of law. How could that clause be interpreted in the way that the Court of Appeal has sought to interpret it? That then brings me to the question of what we say is the proper interpretation of the provision in question. If we can just turn it up again, it's in Authorities Bundle 1 at tab 1. And you have, in fact, over the course of the day, heard many of the submissions that I'm going to make on this. So, first of all, the operative part of this clause is the phrase at the end, liable to be questioned in any court. And that is materially identical to the phrase familiar from Section 4.4 of the Foreign Compensation Act. There are three differences between this clause and the clause at Section 4.4. The first is that this clause enumerates different types of decisions, determinations, awards, orders, and other decisions of the tribunal. In my submission, that makes no difference. It reflects the fact, as we've seen, that the IPT makes these different types of decisions, awards, determinations, and orders, and they're all listed here. But specifically, this doesn't cover purported determinations, purported awards, or purported orders. That's what's significant from the anisminic perspective. The second point is it contains the words in brackets, including decisions as to whether they have jurisdiction. And the court has my submission as to what those words mean. They identify another type of decision that the tribunal may make, which is a decision under Section 65 as to whether or not it has jurisdiction. But they contain the same limitation as the words outside the brackets. They only apply to valid decisions as to whether the tribunal has jurisdiction. They therefore make it clear that this is a tribunal of the type identified by Lord Esher in the Inland Revenue case that has the power to decide the facts to determine whether it has jurisdiction, but they do not give it the power to err in law when deciding whether it has jurisdiction. So that's the meaning of the words in brackets. What the words in brackets cannot do and cannot be construed as doing is in some way acting as an extender for all of the rest of the clause, so that where it refers to a determination, it is now to be taken to be referring to a purported determination, which in fact it had no power to make. That's the way that the words in parenthesis have been interpreted by the Court of Appeal. Now, in my submission, that's an impossible use of the English language, even if you ignore all of the history that we've just spent most of the day looking at. It's just not grammatically correct.
Could I raise with you at this stage
Yes,
the
my
point I was thinking about raising earlier? It's simply this. The words are quite specific.
Yes, they are, my lord.
Decisions as to whether they have jurisdiction.
Yes.
Now, it occurred to me that the real importance of annus minic was that before annus minic, there was no doubt that if a tribunal went outside its jurisdiction in what Lord Reid called the narrow sense, then an ouster clause wouldn't work. And by the narrow sense, he meant the question whether they had the power to enter upon the inquiry at all,
Yes.
that threshold question. And the point of annus minic was that it expanded the idea of jurisdiction into a wider sense of encompassing errors made in the course of the inquiry of various kinds, which took the tribunal out of its proper function.
Yes.
And if you're talking about that latter type of error, it's difficult to describe that as involving a decision as to whether they have jurisdiction.
I agree, my lord.
On the other hand, in the narrower sense, if you're asking, do we have the power to take this case, for example, you are actually making a decision as to jurisdiction.
Yes.
So I just raised for discussion, one possible reading of this might be that it's concerned with what it says, decisions as to whether they have jurisdiction, and such decisions would be decisions taken at that threshold stage.
My Lord, I respectfully agree that it is talking about a preliminary decision made by the tribunal as to whether it has jurisdiction in that sense. And in my submission, when it says that, it's talking about all the factors we looked at under Section 65. Because the tribunal's jurisdiction, as we've seen, was set out in the various provisions of Section 65. So the tribunal has to make a decision as to whether it has jurisdiction under Section 65.
Yes, I mean, it might be thought to be slightly curious that the decisions as to whether it has jurisdiction under Section 65 at all is apparently protected from judicial review, but errors that it thereafter makes in considering the complaint or proceedings or reference would not be protected.
No, in my submission, there's no difference in the level of protection because they're just different types of decisions. So this clause lists...
Well, but the last
let me just explain.
Well, right.
Sorry. This clause lists 4 different types of decisions. A determination, an award, an order, and a decision as to whether it has jurisdiction.
Well, other decisions.
Other decisions.
Including
or
decisions as
as to
to
whether it has jurisdiction.
And it
Now,
could be thought that the 4 words did not necessarily include decisions as to whether or not it had jurisdiction.
Exactly, my lady. But all of those are only protected from judicial review insofar as they are valid decisions. Because it does not say purported determination, purported award, purported order, purported other decision, or purported decision as to whether it has jurisdiction. And so there is exactly the same degree of protection from judicial review that applies to all of the decisions that this tribunal may make, and it's exactly the same degree as that which applied in Annis Minnick under Section 4.4, because it's the same test and it's the same limit.
Well, the other way of putting it is they're all equally amenable to judicial
Yes,
review.
absolutely, my lord. Absolutely, they're all equally amenable to judicial review. So there isn't any magic about the words in parenthesis. All that the words in parenthesis are doing is identifying a particular type of decision, which is a particular type of decision that this tribunal is very likely to have to make, given the terms of Section 65. Now, there's an added wrinkle to this, which is that, as we saw, that provision first came in 1985. And as I've pointed out, shortly before that decision in 1985, the decision of the House of Lords in Khawaja had some quite important things to say about precedent fact. That's his Authorities Bundle 4.
Sorry, but before we go to Khawaja,
Yes.
could I just pursue a little bit further with you? If you read it, I'm wondering if there's a possible, I mean, I don't know the answer to this, but I'm wondering if there's a possible rationale that, say, for example, it's a complaint under the Human Rights Act.
Yes.
If the tribunal, if the IPT wrongly takes it, and that wrong decision is protected, just go with me for the sake of the argument, that that wrong decision to take it is protected from judicial review, but errors that it then makes in dealing with the proceedings are not protected, then at the end of the day, the court, by means of judicial review, can deal with any errors in dealing with the merits of the proceedings.
That's true.
Errors of law, okay? What it wouldn't deal with would be whether it ought to have been in the first place, the IPT dealing with this, or an ordinary court. But in a sense, provided any error affecting going to the merits can be corrected, it's not a matter of great importance whether the proceedings have originated in the IPT or in some other court.
I take your lordship's point, but in my submission, the correct approach is that whether it's making a decision as to whether it has jurisdiction or a merits decision, it will be amenable to judicial review to the same extent. So if it makes an error of law in deciding that it has jurisdiction, that could be judicially reviewed. So, for example, the tribunal decides that a county court is not a judicial authority, and therefore it decides it can take jurisdiction over a warrant issued by a county court judge. That's an error of law in a decision as to whether it has jurisdiction. That decision is a nullity. The tribunal does not have jurisdiction. That decision is judicially reviewable. But let's say that the court decides wrongly that, as a matter of fact, that a warrant has been issued when, in fact, no warrant was issued. That's a decision of fact, but that's a decision that falls within the jurisdiction of the tribunal in this sense. It has the power to decide whether or not the facts which give rise to its jurisdiction exist. Now, that in our submission is what the words in parenthesis mean. The response of Her Majesty's government is to say, oh, well, that raises difficult questions as to what are questions of law and what are questions of fact. Well, that may well be so, but those questions arise whenever you're considering judicial review. It's absolutely standard that you're never going to abolish those difficult questions. The question is whether the right answer to that is to conclude that Parliament intended wholly to oust judicial review, given all of the background that we have already looked at. Now, the only other, I was going to look at Khawaja before we come on. So that's Authorities, Volume 4, tab 53. I don't propose to look at this in detail, but just at the head note. The issue here...
Page?
Sorry, I beg your pardon, my lord. It's page 2041. And the issue here, it was a judicial review of a detention based on an individual being an illegal entrant, which made them liable to be detained under the immigration legislation. And the question was whether it was sufficient, whether the right test was whether the Secretary of State had rationally concluded that somebody was an illegal entrant, or whether the question whether they were an illegal entrant was an objective question of fact that had to be determined on the balance of probabilities, because there was no jurisdiction to detain them unless they were, as a matter of objective fact, an illegal entrant. And the House of Lords concluded it was the latter, that there was no jurisdiction to detain unless, as a matter of objective fact, they could be proved, and the burden of proof was on the Secretary of State to be an illegal entrant. And we see that if you look at page 75 at the bottom of the page, at finding 2, and then at page 2043, sorry, that was 2042, 2043, on an application for judicial review of an order detaining a person as an illegal entrant, it was for the executive to prove to the satisfaction of the court on the balance of probabilities the facts relied on by the immigration officer as justifying his conclusion that the applicant was an illegal entrant. Now, that decision was made in 1983, and in my submission, it provides further context for why decisions as to whether they have jurisdiction would be singled out in the parenthesis, because the concern, my submission, may have been to ensure that the establishment of the facts giving rise to jurisdiction was a matter for the IPT and not a matter of objective fact for the court.
They could have said that, could they not?
Well, indeed, my lord, and in my submission, that is what they said. But my case doesn't hinge on Khawaja, because as the court knows, we say you get the same point from the extract of Lord Isha cited in Annis Minnick itself. It's exactly the same point. So all of these points take you to the same place, which is that the words in parenthesis are not a material difference from Annis Minnick. They're simply an enumeration of another type of decision to which the anisminic principle applies. It doesn't apply to a purported decision. And as a minimum, what would you have expected if Parliament had intended to oust judicial review? The first thing you would have expected was a definition of decision, determination, award as including a purported determination, as you saw in the 1969 Act and the 2003 Bill. The second thing you would have expected in my submission is an express provision saying there shall be no judicial review for error of law. And it's striking that it doesn't say that. And that's particularly striking given the history that we've looked at, the case law, and the history in particular in relation to express no certiorari clauses. There is no certiorari clause here, or modern equivalent, excluding judicial review. And you would expect that as a minimum. Now, the only other point that's made is that there's an express reference to appeals. That is not surprising, given that there is provision for the Secretary of State to make orders to be placed before Parliament providing for appeals. And it's also said, well, if judicial review is not excluded and appeal is dealt with separately, what's meant by the phrase liable to be questioned in any court? What content does it have? And the obvious answer to that is that there are various circumstances in which somebody might seek to question a valid decision of the IPT before a court. Just to give an example, let us say that the IPT ruled that a particular surveillance operation or the interception of communications was unlawful. And let's say that the individual who brought that claim was then standing trial in a criminal proceeding, and the prosecution sought to rely on the intercept that had been obtained. In that situation, it would not be open to the prosecution to argue that the IPT had been wrong as a matter of fact in deciding that the intercept had been unlawfully obtained. Couldn't question that decision. And the same point, of course, applies the other way around. If a person had failed to establish that there was any violation in relation to a complaint made, for example, of assault or of trespass before the IPT, they couldn't then go to the High Court and make exactly the same allegations and say the IPT got it wrong. So in our submission, there is a perfectly understandable, coherent, credible interpretation of Section 67(8), which does not have the dramatic consequences which the Court of Appeal found that it did. So why then did the Court of Appeal find that this was a valid ouster clause? Let's look at the judgment, which is in Core Bundle 2, page 313. Starting at page 325, paragraph 24, my lord. Rather touchingly, the Court of Appeal says, although a lot of authorities were cited to us, this case turns on a short point of statutory construction in relation to RIPA. Now, actually, in a sense, they're right. But the error with respect that they made was that they disregarded 300 years of case law that was cited to them and treated the matter as governed only by Annus Minnick. And you will see that their focus in terms of construction is only on the specific terms of Section 4.4 of the Foreign Compensation Act. They ignore the hundreds of years of case law, including much broader ouster clauses that were held not to wholly oust judicial review in the centuries before Annus Minnick. So that's the first error. Then paragraph 33, we can see that approach. In my judgment, says Lord Justice Sales, the language used in 67(8) is materially different from that at Section 4.4 of the 1950 Act. The context for the two provisions is also materially different. So our first objection to that is that we say that focus is much too narrow. Lord Justice Sales treated this as if it were only about anisminic and not about the whole of the supervisory jurisdiction of the High Court as established over generations. And secondly, we say that the conclusion there is wrong. The wording is not materially different for the reasons I've already explained. Now then, the essential error in the court's approach is developed at paragraph 34. In anisminic, the word determination was taken to exclude purported determinations in excess of jurisdiction, where the excess of jurisdiction arose because of an error of law. But the drafter of section 67.8 has expressly adverted to the possibility of the IPT making an error of law going to its jurisdiction by the words in parenthesis, including decisions as to whether they have jurisdiction. Now, the error is obvious there. There is nothing about the words in parenthesis that refers to an error of law any more than there is in the words in the remainder of 67.8. All of the provisions in 67.8 only refer to decisions or determinations. They say nothing about error of fact or error of law. So there is no reason for assuming that the reference to a decision as to whether they have jurisdiction includes a decision flawed by error of law, whereas a determination does not cover a determination flawed by error of law. But that's what Lord Justice Sales says, and we say that that's the critical error. And then he reasons from that as so far as the word decision is concerned, it's not tenable to apply the simple distinction relied on in anisminic. We say that is wrong between a determination and a purported determination. We say that is simply a misconstruction of the phrase. And he says at 67.8, the word decision is stated to include a decision which might be found to have been made without jurisdiction because of an error of law on the part of the IPT, a purported decision. With respect, that is simply wrong. There's nothing to that effect in 67.8. So that's the critical error of construction at paragraph 34. Then at paragraph 37, after a discussion of the words in parenthesis, returning to anisminic, at the end of the paragraph, Lord Justice Sales says that in anisminic, the members of the appellate committee considered that if the Commission made a determination following a procedure which did not properly comply with the rules of natural justice, it would be a purported determination, not a real one, and judicial review would be available, notwithstanding section 4.4. But in the context of section 67.8, the IPT's decision on the point would be a decision as to whether they had jurisdiction to proceed in the particular way in issue, which could not be questioned in any court. Now, with great respect, we say that is simply wrong. Again, a decision by the IPT to proceed if, say, one member of the IPT had an interest in the matter and therefore there was an appearance of bias or actual bias is not a decision as to whether they have jurisdiction. Then at 38, he says it is implicit in reading 67.8 in this way that Parliament considered the IPT can be trusted to make sensible decisions about matters of this kind and on questions of law which arise and need to be decided. There's nothing implausible about that because of the quality of the membership of the IPT. With great respect, we say this entirely misses the point. First of all, it is trite law that you cannot exclude judicial review by implication. So the reference to what it may or may not be implicit, we say, is misplaced. But secondly, the question whether judicial review may be excluded has nothing to do with the actual or perceived quality of individual members of a particular tribunal and whether they may be trusted by Parliament to make sensible decisions. This is a question of constitutional function. When we talk about constitutional competence or capability, we're not talking about how good a judge somebody is. We're talking about what their role is as the authoritative and independent dispenser of the common law. So again, we say that paragraph is misconceived. Then at 39, he says it might be objected that the phrase decisions as to whether they have jurisdiction could be taken to suggest it's only where the IPT gives its attention to a particular issue and reaches a considered view on it that it's made a decision as to whether it has jurisdiction. Well, yes, it might indeed be said, and indeed that is the obvious, natural, grammatical meaning of the phrase. But he says, however, 2 points can be made. First, this is what has happened in this case. The IPT heard submissions about the meaning and effect of Section 5 and reached a reasoned decision on that point in the course of moving towards its determination. With respect, we say that is a non sequitur, that's simply wrong again. And then he says, secondly, I don't consider this interpretation is correct. There's no good reason for reading Section 67.8 in this narrow way. It would create an unjustified distinction between advertent and inadvertent errors of law. The whole premise of this is that he assumes that a decision whether they have jurisdiction can only refer to a legal decision and therefore to an error of law. And at no point does he consider the point that the words in parenthesis, just as the words outside parenthesis, can be reserving findings of fact to the tribunal, but errors of law to the High Court. So it's the same underlying error.
He doesn't consider the argument that the rationale might be that if you're allocating a judicial function to a specialist body,
Yes.
rather than to the ordinary courts, you might not want, Parliament might decide there's no point having judicial reviews over which body ought to be performing the task, provided at the end of the day there's a means of correcting any...
Yeah, he doesn't consider that, my lord.
No.
He doesn't consider that. And so then at the end of 40, remarkably, he redrafts the words in parenthesis. He says, in my view, the phrase decisions as to whether they have jurisdiction has the following straightforward meaning, appropriate in this public law context, decisions in relation to their jurisdiction. Well, again, we say that that is an entirely flawed exercise in any case of the construction of a statute, and particularly in relation to a clause of this kind. He then says that he thinks the use of the word determination elsewhere in the regime tends to indicate Parliament intended it to mean both a real and a purported determination. With great respect to Lord Justice Sales, I do not understand the references he makes there to sections 68, 4 and 5, which have nothing to do with purported determinations. More fundamentally, what he has missed is the provision in section 65.11 that we looked at earlier today, in which the draftsman refers specifically to a purported authority in the context of establishing what is or what is not a challengeable circumstance. So the draftsman was well aware that if you're talking about a purported decision or a purported authority, you need to say so expressly. And again, this point is simply ignored. So then, that's his linguistic construction of section 67.8, and we submit it's flawed in every respect for the reasons I've given. He then says at paragraph 42 that these linguistic points are strongly supported by the statutory context in which 67.8 appears. It is clear that Parliament's intention in establishing the IPT and laying down a framework for the special procedural rules was to set up a tribunal capable of considering claims and complaints against the intelligence services under closed conditions which provided complete assurance that there would not be disclosure of sensitive confidential information. I respectfully agree, although of course the jurisdiction of the tribunal is wider than that, but it is a non sequitur to suggest that because of that context, Parliament should be taken to have intended to oust judicial review. Now, judicial review is infinitely flexible. It adapts to different circumstances. At the present time, as this court is well aware following Haralambous, the court has decided that judicial review is sufficiently flexible that in a case where a lower court or tribunal had the power to consider a closed procedure, so does the court on judicial review. Prior to Haralambous, the approach that was taken in cases like Rossminster was that if you couldn't inquire into the underlying reasons for a decision, the claimant might well not be able to succeed in a claim for judicial review because they wouldn't be able to establish that there were any flaws in those reasons. Now, this is a point that's going to be further developed by my learned friend, Mr. Chamberlain. But the point I make is simply that it is a non sequitur to suggest that because the context is national security and because of the need to keep confidential material confidential, that the High Court could not be trusted with a judicial review claim. The High Court has ample powers that enable it to do just that.
But one can quite frequently decide a question of law without reference to the underlying factual material and evidence. The Evans case, whatever you think of the decision in the Evans case, is an example of that. We never saw the letters in question.
And my lady, this case is another example, because what the IPT has done is it has developed a procedure where it will very often decide a question of law on the basis of open assumed facts. And that's exactly what it did in this case. There was no closed process in this case. It was a pure question of law that was decided by the tribunal. And there is no reason why Parliament should have been taken to have intended wholly to oust judicial review for error of law in circumstances such as that. And this is the place where we say, apart from these concerns being unmeritorious on the facts, they are wrong in principle, because what the Court of Appeal is here seeking to do is to adopt a broad purposive construction of section 67(8), which is not warranted by its language and the history which underlies that language, on the basis of what the Court of Appeal is assessing as a policy consideration. But if Parliament had thought that the circumstances here were so extreme, the onus was on Parliament to draft a valid ouster, as it sought to do in 2003 before it resiled. It is an usurpation by the court of the proper function of Parliament for the court to seek to imply an ouster on the basis of policy considerations. The final reason that was given by Lord Justice Laws, we see at paragraph 46.
Sales.
Sorry, I beg your pardon, Sales. Lord Justice Sales.
We're not going to speculate about what Lord Justice Laws would have thought of
I
this
think we
case.
know what he would have thought, my lady. So the final reason given by Lord Justice Sales was the obiter dictum of Lord Brown in the A and B case, which you see set out at paragraph 46. And the court has my submission on this, that it's a matter that wasn't in issue. In fact, it had been conceded. There is no underlying analysis. There's no suggestion that any of the relevant authorities were cited, and it does not appear to have inhibited Lord Brown from agreeing with Lord Phillips in Cart that there was no case of an unambiguous ouster after Annis Minnick. I'm very aware of the time. I don't know if the court will be prepared to give me just another few minutes, in which case...
Well, we were late coming back into court, so if you could manage to complete it in 3 minutes, that would be fine.
My lady, I will endeavour to do so. So those are the reasons we say that the Court of Appeal got it wrong. So what do the interested parties say? And the first thing that they say is there's no presumption against ouster here because the IPT is a court of law. And they rely on a dictum of Lord Diplock from the Re-Racol case. Now, we've dealt with this matter in detail in our reply note. It's paragraphs 2 to 18 in our reply note, which I would invite the court to read overnight if you have the time. We have a number of answers to this point. In the first place, it's ahistorical because, as the court has seen, in fact, most of the early ouster cases concerned certiorari against courts, against lower courts. That's how certiorari had its origins. There's no suggestion that any of the relevant case law was cited to Lord Diplock. Lord Diplock himself resiled from this proposition in O'Reilly and Macman. Later cases have made it clear it is not good law, including Siva Subramanian, and indeed the decision of this very court in Cart. And in our submission, it has no basis in principle, because no coherent distinction has been suggested where the line could be drawn between a tribunal of limited statutory jurisdiction and a court of law. What is the dividing line? And what is the reason in principle why a restrictive approach should be taken in ouster to one but not the other? The constitutional principles I have identified apply with equal force to both situations. So for those reasons, and also the reasons in our reply note, we say that is a bad point. They also suggest that annus minec is based on a notion of nullity and that is no longer good law. Well, we say that's, again, a bad legal point. As recently as Lumba, a majority of the Supreme Court upheld what was said in annus minec about nullity. There has always been a presumption of regularity. It has never been the case that an invalid decision flawed by error of law is void ab initio for all purposes. It will always be presumed to be valid unless challenged timiously in the right forum. It's always been the position and remains so now. So there has been no change in the law in that respect since annus minec. And finally, they identify other forms of limitation on judicial review, such as limitation periods, and those we say are entirely different in kind and cannot be compared to a total ouster of judicial review. That leaves issue 2. I don't intend now to embark on a detailed analysis of issue 2. You have it in my written case. Essentially, the structure of the argument is the same as the points we make in relation to issue 1, and in particular the analysis of Lord Justice Laws. But the submission is that the logical conclusion to be drawn is, in fact, there is no power to make a complete ouster of judicial review.
Ms. Diner, issue 2 is big.
Yes.
In a sense, it's even more exciting than issue 1.
Yes.
But you've run out of time.
I have, my lord, but...
And insofar as that's due to us asking you questions, and me in particular asking you questions, I really apologise. You have no time to deal with issue 2. My question is, if you did have more time,
Yes.
what in particular would you be asking us to look at? Because speaking for myself, I would like to look at it.
Well, my lord, there are... The key text in relation to issue 2 is the judgment of Lord Justice Laws in Cart,
Yes.
where he sets out the analysis. We have also identified in our case a number of constitutional texts which we say support it, including Dicey and Lord David Hume from the Scottish side, and an extract from Blackstone. We've also identified a number of extracts from the case law that support it, and one of those is the extract from Bradlaugh, which I showed the court this morning, and the Cheltenham Commissioners, that when you have the courts, in the face of express no certiorari clauses, saying this clause does not prevent us from exercising our supervisory jurisdiction to grant certiorari, you have to ask the question, is this any more an exercise of statutory construction, or is it something greater? It's a refusal by the courts to accept constitutionally that their role can be so limited. So that's the essential outline, and you'll find all of the details are fully set out in our written case.
Very well.
The final point is that there is a separate argument based on the constitutional statutes, which cannot be repealed by implication, and I also commend that to the court.
Very well, thank you.
Unless I can be of any further assistance, those are my submissions.
Well, we've asked you plenty of things and put plenty of things to you. And I'm not sure which of your learned juniors, as you have so many, is the one
Indeed,
to be called upon.
too,
Is it Sir Geoffrey or...
My lady, even if there were time, I would have nothing to add.
Thank you. Very well. Well, we will adjourn now and look forward to hearing from Mr. Chamberlain first thing in the morning. Yes, thank you.